y'all. Welcome. It's been some updates to the Jay-Z, Sean Diddy Combs case against, Jane Doe. You know, Jay-Z and his lawyers have been fighting to get this thrown out. And now they're coming up with, hopefully it can get thrown out on a technicality type thing, citing laws that weren't available yet. Supposedly when the alleged crime took place, the law that she's filing under was not a thing yet. That law didn't go into effect until December of 2000, I believe. And whenever this thing happened, it was September of 2000. So his lawyer, Jay-Z that is, has cited all these laws and about how she's not supposed to be able to file under this because of this and this and this. Anyway, so I found the document actually. Alex Spiro had written to the Judge Torres. Let me share my screen. So it says, Dear Judge Torres, we write on behalf of the defendant, Sean Carter. Mr. Carter seeks to file a motion to dismiss first amended complaint in accordance to all that legal mumbo jumbo. Mr. Carter sent a letter to the plaintiff setting forth the basis for this motion and advising that Mr. Carter would file this pre-motion letter if plaintiff chose to stand on her FAC. Plaintiff was required but failed to report to Mr. Carter's letter within 5 business days by December 27th. Mr. Carter interprets plaintiff's silence as confirmation that she will stand on the FAC as pled. Accordingly, Mr. Carter submits this pre-motion letter concerning his anticipation motion to dismiss, which will raise the following arguments. First, plaintiff cannot recover for her sole claim under the Victims Gender Motivated Violence Protection Act, the GMV law. As a matter of law, because the statute does not have retroactive effect. And that's what I was trying to explain to y'all, because the alleged incident, and it says it right here, plaintiff asserts the violation of the GMV law for conduct that purportedly occurred in September 2000. But this law was not enacted until December of 2000, 3 months after the FAC claims the conduct occurred, and cannot apply retroactively to create a cause of action unavailable to the plaintiff. So they're not even going with the fact that maybe, he didn't do it. Now they're trying to just get it thrown out on a technicality, which is a good defense. I mean, if you don't want it to go to trial, you got to stop it at the beginning. Okay, so this shouldn't even have been filed because it has no basis because, if this is all true, I don't know the law that well. I'm not a lawyer by trade at all. But this is what Alex Spiro is going on. He was like, second, even if the GM law had a retroactive effect, it does not, to prevail, plaintiff must show that the violation conduct was committed within the New York City limits. So now they're saying if it did have a retroactive effect, it only pertained to crimes that happen within the New York City limits. Because I think she indicates it on here, the FAC alleges that the violative conduct is forced as contact, but does not assert that this conduct occurred in New York City, nor could it. According to FAC, plaintiff was driven from Radio City Music Hall to a large white residence with a gated U-shaped driveway, a drive that took 20 minutes. This is where the alleged assault took place. The FAC's description of the residence in question, however, combined with public records, confirmed that any such residence to exist to the extent it existed at that time would have been located outside the territorial boundaries of New York City. So they are like being exact. Like this couldn't, because of the parameters of where the alleged incident took place, because it took place, so she says, allegedly outside or 20 minutes away from Radio Music Hall, that means it didn't happen in New York City. So she can't file under the GMV law. So then they say, thirdly, any viable GMV law claim is time barred under New York's Child Victim Act, which preempts plaintiff's GM law claim. The FAC alleges the conduct occurred 20 plus years ago, well outside the CVA statutes of limitations. Though the CVA was amended in 2019 to create a 2-year, 6-month revival period, the period expired in August of 2021. Plaintiff seeks to plead around the statute of limitations issues by asserting a claim under the GMV law, which contains a longer revival period. Courts in this district, however, have recognized that the CVA's revival period preempts the GMV law, overlapping the extended one. So now they're saying, even if she can't do it under that, because the statute of limitations has gone up. So it's like he's pulling all these things, all these facts, all these laws, and she's missed the deadline or the parameters or the eligibility in every scenario. So that's what they're going on. They're trying to get it thrown out on a technicality. So then Alex Spiro then writes a letter to the judge saying, "Dear Judge Torres, we write on behalf of the defendant, Sean Carter, concerning his motion for an order of the preservation of evidence. In an effort to resolve the motion on December 30th, 2024, Mr. Carter served a document preservation notice concerning evidence related to his actions and others. Given that Mr. Buzbee's counsel has indicated that they are permitted to accept service on behalf of Mr. Carter, effectuated service of this notice today. As such, the court need not to intervene and to issue a preservation order at this time. Accordingly, Mr. Carter respectfully requests to withdraw the motion as moot." So that was filed on 12/30. That was Monday. Okay. So then the Buzbee law firm responds. Okay. Did I say tax attorneys? Okay. Your Honor, I write on behalf of the plaintiff, John Doe, in response to the defendant, Sean Carter's letter dated December 30th, 2024, docket number 56, to which defendant requests leave to file a motion pursuant to Federal Rule of Civil Procedure to dismiss plaintiff's first amended complaint, document number 29. Defendant states his intention to move for dismissal on the grounds that Doe cannot pursue her claim under the New York City Victims of Gender Motivated Violence Protection Act, NYC, admin code, blah, 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 because the GMVA does not have a retroactive effect. However, neither the Second Circuit nor the New York Court of Appeals has endorsed this reading of the GMVA. In support of his argument, defendant cites a trial court order decided on an unopposed record, which is merely persuasive authority. And then they say they cite the case in 2023. Plaintiff failing to brief GM at VPL, the law retroactively issued, blah, 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 blah. Plaintiff failing to address they're saying that they're failing to address the retroactive issue. So defensive arguments as to the GMVA is unpersuasive, as it is contrary to the law's primary intention to make it easier for victims of gender-motivated violence to seek civil remedies in court. Not as defendant would have it, make it harder. New York City passed the GMVA in light of the void left by the Supreme Court's decision, United States versus Morrison, blah, 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 blah. Morrison struck down the federal right of actions for victims of gender-motivated violence under the Violence Act Against Women's Act. So now he's putting in a VAWA law out there, holding that Congress lacks the authority under the Commerce Clause or the 14th Amendment to pass such a remedy. The Supreme Court, however, urged local governments to provide a remedy to women like Morrison, who had been brutally marred, as no civilized system of justice would fail to provide her a remedy. New York City rallied to that call and passed the GMVA. GMVA shows the council intended to fill the void left by Morrison. The city council recognized that gender-motivated violence is widespread throughout the United States, and that 3 out of 4 women will be the victim of a violent crime sometime during their lives. NYCM, okay. The council also concluded that victims under gender-motivated violence frequently face a climate of indifference and hostility in the court system. The council sought, therefore, to create a private right of action for victims of gender-motivated violence to resolve the difficulty that victims face in seeking court remedies by providing an officially sanctioned and legitimate cause of action for seeking redress for injuries resulting from gender-motivated violence. NYC, blah, blah, blah. It is fundamental that in interpreting a statute, the court should attempt to effectuate the intent of the legislature. Okay. The council intended the GMVA to make it easier for victims of gender-motivated violence to seek court remedies, and it intended the same when it passed the 2022 amendment to the law. Similarly, defendants also intends to seek dismissal on the grounds that any viable GMV law claim is time barred under New York Child Victims Act, which preempts plaintiff's GM law claim. However, this court in Doe versus Gooding found that local anti-discrimination laws are generally not preempted by state law in New York. Finally, defendants intends to seek dismissal on the grounds that the conduct alleged in the FAC could not have occurred in New York City based on plaintiff's description of the residence in question, combined with public record, confirms that there's any such resident was located outside of New York City. As defendant seeks to rely on evidence outside of the pleadings, which would transform a motion to dismiss to one of the summary judgments, and as a discovery it is not yet underway, it is respectfully submitted that defendant's proposed motion is procedurally improper and should be denied. In light of the foregoing, plaintiff respectfully requests the courts to deny defendant's request for motion. So he's requesting for the motion to dismiss to be denied because they haven't even started with the discovery yet. They're just basically, Buzbee is saying they're throwing all this stuff, saying that there was no residence at the time that fit the description, but they haven't put forth the discovery, and they're asking for his motion to be denied because it's not based on anything. So I get it. I get it. I get it. So the next letter, it was filed today. So this was filed by Spiro today. Dear Judge Torres, we write on behalf of the defendant Sean Carter concerning his motion for an order for the preservation of evidence. In an effort to resolve the motion on December 30th, 2024, Mr. Carter served a document preservation notice concerning evidence related to his actions and others. Given that Mr. Busbee's counsel has indicated that they are permitted to accept service on his behalf, Mr. Carter effectuated service of this notice today. As such, the court need not intervene to issue a preservation order at this time. Accordingly, Mr. Carter respectfully requests to withdraw the motion as moot. So he's just withdrawing the motion to preserve evidence, I guess, right? Guess what that means. Okay, so then the very last thing. Okay, so all right, so this is actually from the judge or the courts. Okay. All right. So it says, this is from Judge Torres. The court has reviewed defendant Sean Carter's letter seeking leave to file a motion to dismiss plaintiff amended complaint and plaintiff's letter in opposition. Carter's request to file a motion to dismiss plaintiff amended complaint is granted. So by February 6th of 2025, Carter can file his motion. By February the 28th, the plaintiff shall file their opposition papers opposing the motion. And by March 14th, Carter shall file his reply. The clerk of the court is respectfully directed to terminate the motion. So ordered. So she is going to at least listen to the reason for the dismissal. But court things will be held up in court for the longest. And he wants this like over and done with. He wanted it like shut down like immediately. But his money, I guess, still ain't that long. He got a lot of it, but it clearly ain't that long because he's got to go through the process. But he has moved everything up. And if they throw it out, I mean, this will be a win for Diddy. And this is one thing why I'm thinking Diddy, we've heard stories about him holding up in a cell, not wanting to come out and be served or deal with the other cases. I think there are other Tony Buzbee cases. I think if he can get this one thrown out, then there'll be some type of precedence. And I'm thinking that's why they're holding up everything, because they think that if this one can get thrown out, then it might be a domino effect on the others because they'll follow the same on the others that have filed within those dates and parameters and what have you. So it's a method to his madness. I really feel like the councils are working together, meaning Alex Spiro and Agna Filio and the like. And P. Diddy is holding up in his cell, not wanting to be served, pushing back the case docket for all of the cases that Buzbee has against him. And he doesn't want any of them to land until Jay-Z finishes with this one. That's my opinion. That's my opinion. And I'm entitled to it. Exactly. That is my opinion, and I'm entitled to it. So I don't know. This court stuff is messy. And I'm glad that, you know, I mean, it could be long and drawn out, and just imagine those people that don't have the money to fight, though. Like, they get caught up in cases that they're getting blamed for and don't have the actual finances to go back and forth, because they can drag this out. Even though I know the goal is to get it squashed and moved and thrown out or whatever, it still might take 6 months for them to throw it out. So there's that. Anyway, leave a comment below. And before you leave the building, like this video. And I want to welcome all my new subscribers. Thank you for rocking with me on my journey. 2025 is going to be a great year for everybody. I'm putting it in the universe. Everyone be blessed. Peace.